Hello, everyone, and welcome to Social Media. Any post can and will be used against you in a court of law. A 1-hour CLE presentation presented by the Dallas Association of Young Lawyers. The CLE number will be provided at in the chat function in Zoom. Please feel free to use the Q&A function within Zoom during the presentation with any questions you might have. We'll try our best to answer any of the questions at the end of the presentation. Without further ado, let's meet our panelists. Looking for ways to connect in the new world of COVID-19 and social distancing, Americans are spending more time online. Recent data from Kantar suggests a 61% increase in social media engagement and a 37% increase in overall Facebook usage. Consumer research data published indicates a 2/3 increase in social media usage to those confined to their homes during quarantine. With more internet use, particularly given additional free time, both plaintiffs and defendants are increasing their social media usage. Litigation strategies can benefit significantly from this new social media surge, which begs the question, how and why does increased social media usage matter for litigation? To answer those questions and many more, we have two attorneys joining us today, Jason Bloom and Angela de Cespedes, joining us, who are both authors of chapters from Understanding the Use of Social Media in Litigation, Leading Lawyers on New Evidence Collection Methods and Necessary Precautions for Clients. Jason Bloom is an experienced trial and appellate lawyer and chairs the copyright practice group at Haynes & Boone in Dallas, Texas. He routinely represents clients in First Amendment and media cases before trial courts, appellate courts, and the Supreme Court of Texas. Among his other affiliations and engagements, he is the past chair of the Dallas Bar Association's Media Relations Committee. Angela de Cespedes is a partner of Sal Ewing, Arnstein & Lehr in Miami, Florida. She's a litigator licensed in Florida and New York and has a particular interest in the interplay of social media and online content, specifically concerning sports, entertainment, and the hospitality industries. All right, let's get started. Thanks for joining us.
Yeah, thank you, Callie. Thank you.
All right, let's just jump in. The first question, is there a line to what can be found and used on social media? Is there an expectation to that privacy? As we know, courts have accepted information gleaned from social media posts, taking the stance that anyone posting on social media has no reasonable expectation of privacy. Angela, let's start with you. How far can attorneys go when it comes to gathering information from social media?
As long as you're not pretending to be somebody else in order to friend them or connect with them, and the information is out there and available to the public, there's no limit. And even if the privacy settings are set, regardless of the social media platform, I can't tell you how many times I've gone before a judge, showed some of what's available, or sent some discovery out, or deposed a party, gotten information about what they've got on there, and taken it in front of a judge. And it's very simple. Most social media platforms, Facebook's probably one of the easiest to navigate, and Instagram, they actually have, a one-click button where you can download everyone's, entire profile, every post, every comment, every picture, every video, and the judge will have the other side typically change their password for a set period of time, where you can go on and have your IT people or a third-party vendor do that. You capture everything, you take it, and then they can change their password, back afterwards. So if you post it, chances are somebody's going to be able to see it. That's the best way, I think, to look at that.
There is no limit, Jason. So we know that it's acceptable, as Angela said, to read these public social media posts and to look at what can be seen. But can an attorney or someone else within the firm, friend someone to gain access to this information shared with someone's inner social media circle? And should clients expect to be warned by their attorneys about using social media with care?
I would say yes. I mean, I agree with Angela that there's no real expectation of privacy on social media or generally what you're doing online. And it is permissible, an attorney has certain investigatory duties, and it is permissible to friend somebody perhaps to fulfill those duties, as long as you're doing it honestly. Attorneys in Texas, certainly, and in all jurisdictions, really have a duty of candor, even when dealing with third parties, when you're representing a client. So what you can't do is you can't pretend to be somebody else to friend them and get information. You can't hack into an account. And even doing so through an investigator could raise problems. If you know that an investigator is going out and using a false identity or hacking into an account to get information that you're going to use in litigation, that can be problematic. Now, sometimes investigators are going to do what investigators are going to do, and maybe it's best not to know their methods at all times. But generally, it's not permissible for you to either do it yourself or instruct somebody to use false information. But friending is okay if that's a reasonable way to get the information, especially in a pre-litigation context. Now, it becomes different, and I know we're going to talk about this once somebody has been has had counsel appear on their behalf. Once you know they're represented by counsel, the dynamic changes a little bit.
Okay, and let's start that litigation process that we're here today to discuss. I know there's been some social media outrage, in particular, an egregious example of an attorney instructing their client to clean up his Facebook page and then ultimately deactivating the client's account, before litigation, or in this case, before signing a discovery response that the client did not have a Facebook account. I believe in that case, the court levied a collection fine of $722,000 in sanctions against the lawyer and the client. And obviously they were referred to the state bar. But what does that dynamic look like once you get into litigation? Angela, we'll go with you.
It's interesting because I find even now, which I can't believe it, even now, I can't tell you how many times I depose someone or send out discovery requests, and that's the first time the other side's lawyer is even taking a look at what they've got on social media, which, for me is a great thing. For them, it just continues to shock me, quite frankly, that they don't have that conversation early on. And then there's the other side of the coin, which is you have these overzealous attorneys on the other side, or team members on the other side who take it a little far, or who are very vague, ambiguous when they tell their clients, what they should be doing. I think, if it's my client, the best advice is put your privacy settings up. And I also sit down and explain to them how these things are going to be viewed. So the interesting psychological component behind all of this is people post in a vacuum. They concentrate on that one post, whether it has, a video, whether it has a video and a couple pictures. It's the one post. And they're interested to know how many likes they have, the comments they're getting, and it's really focused on just the one post. Jason and I are not looking at it that way. Okay. Jason and I and every other lawyer, if you're going to be involved in litigation with them, and it's not just litigation, by the way, it's due diligence on corporate and real estate transactions as well. That's being done, and family law issues, all sorts of things. The way we look at it is these things tell a story. It allows us to kind of compile like a psychological, profile of you, what your motivations are, where your interests are, who your relationships are with, who your friends are. And it lets us build a timeline and a story. People don't view their own posts in that way. So it's a conversation I think worth having with clients. But what we typically do is the moment we get wind of something going on, whether it's because there's a claim or because there was an accident or some incident that took place or some dispute, whatever it is, we immediately go on and see what's public and we screenshot all of it. Okay. That way later, if litigation's filed or a deal blows up or something happens, we can compare. So then when the litigation is filed, you say, well, this is what it looked like 3 months ago. This is what it looks like now. That doesn't play well with the judge. And it just doesn't. And judges are really getting more and more savvy, and they will sanction not only the client, they will sanction the lawyer. The whole excuse, from 5-6 years ago, oh, I don't know. I'm not on any social media sites. They don't care anymore. You have to be tech savvy. You have to be social media savvy. It's your obligation as a lawyer. And the judges are really holding people to the fire as a result of it.
Yeah, absolutely. And kind of a question off of that, Jason, and I don't know if you'll actually know the answer to this, but is there a ethical rule between having, you're telling your client to put it on private after litigation has been filed? So for instance, they file suit. The first thing as defense attorneys, we go, we look, it's all open, it's all great, it's all fantastic. We screenshot it, we go back to look, and it's private. Does that on and of its own kind of necessitate something sneaky going on there? Or do you think they just got to their client and told them to put it on private?
Yes, I would say there's nothing ethically wrong with telling your client to put something on private once litigation has started, because once litigation commences, parties are aware that they're very much in the public eye. Litigation is a public proceeding. All of a sudden, you're going to have the media looking into you. You're going to have other people looking into you. And you may not want to have everything that's discoverable in litigation available to the public so that, the case can actually be kind of litigated in public discourse rather than the court. So there's nothing wrong with putting things on private. Where you cross the line is where you actually destroy information. So it's very important at the commencement of litigation to advise clients to retain all of their social media information, especially everything that's relevant. Now, there may be some stuff that's tangential and irrelevant, but before anything is actually deleted or destroyed, you should know about it. And as a general rule, they should preserve really everything in any litigation where social media is going to be relevant or discoverable in any way. But having them put it on private, even having them unfriend people that they think may try to get their information and use it against them, there's nothing wrong with that. Again, I would just make sure they preserve it. Another thing you can do that is not ethically problematic is advise your client to stop using social media going forward once litigation commences. You do have a duty to preserve what existed at the time of you became aware of a claim, but you don't have a duty to keep up your normal course of activity on social media after that. And it's generally advisable for most clients to put it into their social media discourse if it's going to be relevant in litigation once litigation commences.
Yeah, that's great actionable tips that you can, hopefully start implementing prior to this, but now we can definitely after this CLE. Jason, one more question for you. Let's talk about the nitty gritty of every attorney that discovery request comes across their desk, sees a question regarding the social media content of that particular party. We see objections to relevancy mostly. What point does social media contact become discoverable in litigation? And, other than the obvious of I hit a car and here's a photo of the car I hit and now I'm in litigation with this car, what would make it relevant to a discovery response or request?
Yeah, I mean, social media content is really like anything else when it comes to discovery. In order to get to it, you have to show that it's somehow relevant to the dispute and is discoverable. So it's not every case where social media is going to be relevant. More likely in cases involving individuals where some type of look into what they were doing in the past, or if they're continuing to post on social media, is relevant. So if somebody is claiming that after a particular event, a publication of a defamatory article or something like that, they suffered extreme mental anguish, they weren't able to leave the house, their social life was ruined, and you go back to their social media and you're able to show, look, you were out partying, you had a big smile on your face, you were doing all kinds of things. Your life, according to the social media timeline, didn't change at all subsequent to this publication. That's relevant, and you can demonstrate that to a court. If you're in a breach of contract dispute and social media shows that the defendant was having an affair, at some point in time, that's not really going to be relevant. That's probably going to be inadmissible in court. That's character evidence that has nothing to do with the underlying dispute. So the just like any other discovery, you have to show that it's going to be relevant. And to that end, it's very important to very narrowly tailor your social media requests. So don't ask for produce your Facebook account, produce all your tweets, something like that. You've got to say, produce, your Facebook posts from this particular time frame that relate to X, to show that, look, I'm really trying to get relevant information. I'm not trying to just get a glimpse into their entire social media life. Now, ideally, what Angela and I would typically do, and what's typically effective, as Angela mentioned, is get the information on your own through what's publicly available, preserve that, then you probably have more than what you need, and you can send targeted requests to get whatever additional information you think might be out there. So they may, an adverse party may have a very public Facebook account where you can get all the information you need, but their Twitter account may be harder to access, or vice versa. And so you can get stuff from one source, but use what you find that's relevant to narrowly tailor requests to get information from another source as well.
Yeah, every discovery request that comes across my desk has something with social media. And so, Angela, let's talk about what happens when you find gold. When you strike that gold on Facebook, either party, you think you've got it. How do you authenticate that? How do you, we have some young lawyers here who may not know those ins and outs of how to even do subpoena Facebook, and Facebook authenticates that,
You can, but they're going to throw your subpoena in the garbage. Yeah.
Right. I mean, at the beginning, we talked about, anybody can create a Facebook page under any name. So how do we know that's a legitimate, plaintiff or defendant that we're looking at?
Right. So what you want to be careful of, and being the young associate, you're probably going to be the most tech savvy person, in the room or on the case. I'm like, I think Jason and I are probably not typical. Our age group is where there's still, the majority of us, I think, aren't savvy enough to even understand this stuff even a little bit. And any older than us, it's the sliding scale. So what you want to be careful of is you don't want to make yourself the witness. Okay. You want to be very careful of that. You don't want to be the only person who can testify that on such and such a date, you went on this person's Facebook account and this is the way it looked. The easiest way to do it, quite frankly, I found, is to have a paralegal, even an assistant if need be. If the case is big enough, you can hire third-party vendors, discovery vendors that'll come in, or third-party forensics experts, and they will go in and they will capture everything. But one of the easiest ways to do it, if the case doesn't merit it that way, is have somebody screenshot it on their phone, because it'll have the metadata with respect to when the photo was taken, and be as complete as you can when you're doing it. Open the post, open the picture, show all the likes, show all the comments. It's kind of a pain in the butt, but if it's something that's going to be really important to the case, and I save it all at the beginning. It lets you tailor your discovery requests. It lets you give the client an early analysis of what you think the case is worth, what you think the party's motivations are for doing what they're doing, asking for whatever they're asking for, gives you an insight into their living situation, their life, their job, things they may have going on, in their life. And then once the discovery requests go out and they're narrowly tailored, they're going to have a hard time objecting to those. They're going to give you responses. I've been doing this for 21 years, and this stuff has been relevant probably for the better part of the last 15. I've yet to ever see a plaintiff tell the truth about, and I don't necessarily think it's always because they're being purposefully deceptive. They just don't remember. Or have convinced themselves that it's not relevant for whatever reason, and told that to the lawyer. The lawyer's taken their word for it and looked at it themselves. So it's interesting to me. And what I'll do a lot of the time is we'll get the discovery response back, sworn responses, interrogatories, requests for production, whatever the case may be, and then I'll set them for deposition. And people know not to bring a file or documents that your lawyer gave you to a deposition, because the other side can take a look at what you brought. But you know what they always have? Their phone. Same thing as far as I'm concerned, as bringing a file folder with you. Open your phone, please. And you don't know how many people, oh, it's out of battery. Oh, let me get you a charger. Hold on. Open your phone. What social media apps do you have on there? Let me see. And I will actually take my phone and screenshot their phone in the middle of the deposition and make that an exhibit to the deposition, and I'll have them open, and I go open, whatever. Let's take Facebook as an example. Open Facebook. Do you have any posts in this date range? What are they? Let me see them. And the other attorney hasn't looked, has no idea. 9.9 out of 10 times what's there, is freaking out, threatening to call judges, threatening to stop the depo, and you really can't. You really can't. They've got to kind of let you do it. And if the party walks out, they're going to get sanctioned. If the lawyer stops the depo, which they're not permitted to do for any reason, other than there's very limited circumstances. Let me put it that way. You should never stop a depo until you're done asking questions, even if the other side's refusing to answer, because you may never get a second bite at that apple. But that's a different seminar. But I'll sit there for hours with them just looking at everything on their phone. So, and then if they lied or they left stuff out, then you got the leverage you need to settle that case. So,
oh, that's an interesting take. I love that. I've never seen that done. Jason, do you have any thoughts about doing that? I mean, I've never seen that done. I'm obviously not as experienced. How would that kind of work in a Texas depo? I don't know how different they are, but what do you think, Jason?
Yeah, I think the biggest roadblock you're going to run into is if somebody has their phone, like I do, and most lawyers will, has their phone password protected, so somebody can't get into it. And you can't compel somebody in a deposition to type in their password or to give you their password, and they can refuse. And then at that point, maybe you go to the court and say, look, I'd like you file a motion to compel and see if the court will compel them to do so. And then you could get the information that way. But in real time at a deposition, you can't really force somebody to, reveal their password. That being said, a lot of parties are not going to be sophisticated enough to, have their phone password protected. So in that case, it could be permissible. Now you're going to hear people object to privacy concerns, and lawyers may try to stand in the way of it. And, then you get into the sanction issues that Angela was referencing. And sometimes maybe you could get the court on the phone. I mean, that's less common in Texas state court. Some federal courts in Texas have a discovery hotline where you can actually get a magistrate judge on and get rulings on things like that during a deposition. So that's possible. Adding on to what Angela said, just as ways to authenticate social media information, one effective tool can be, once you have it, let's say you found it on your own, just send a request for production asking for them to produce it. If they don't produce the same stuff, then you've got a spoliation issue. You can make an issue out of that. If they do, under Texas rules and federal rules as well, documents that a party produces are generally deemed to be authentic. Now that can be challenged, but that will authenticate them if the other party produces them in response to a discovery request. And the other thing you can do is you can send requests for admissions if you want to do that prior to the deposition, where you attach the social media pages that you've gathered and say, please admit that this is your account. These are authentic pages. And that puts them in a real box to deny that. Now, if somebody denies it, then you've got to dig a little deeper and see what's going on there. But, I've never seen anybody, despite the fact that obviously people can create dummy accounts and, do a lot of things like deep fakes to make it look like somebody's doing something that they're not. I haven't seen that come up yet where somebody's claimed, oh, that's not my account, that's a fake account. I mean, usually somebody knows that they're going to have a real hard time denying their social media account because there's going to be so much information that's individual and particular to them. And they know that at the end of the line, if you subpoena Facebook for the identity of the person behind the account, as Angela said, Facebook and others don't love getting subpoenas and they love fighting them. But at the end of the day, you might be able to get identifying information as to who owns this account. And a lot of companies will cooperate with that type of thing. And just one last point I'd like to make, on the authentication thing, and this doesn't really apply so much to social media, but it's a valuable tool that young attorneys should know about. I'm sure Angela knows about it, and a lot of folks who deal in this space do, but there's a site called archive.org that operates. It's called the Wayback Machine, which basically archives the internet. So they have bots that crawl across the internet and archive pages at various points in time. And it can be extremely valuable in litigation to see what did a page say on X date. And they don't capture every date, they don't capture every page, but there's a lot of stuff they capture. And they have a process whereby you can actually get them to sign an authenticating affidavit for you for use in litigation. You have to make a donation because they're a nonprofit, but nonetheless, they'll sign an affidavit that you can use. Now, they don't capture social media, which is what we're talking about today, but they do capture a lot of other stuff on the internet.
Yeah, no, that's great. I believe I used that in law school to figure out if the article was actually on that site on that particular day. But that's great. And we kind of have a question. We have a question from one of our viewers here, similar along the lines. Jason, I'll throw this one to you. So she says, I've had an attorney in the past objecting to their client showing a driver's license because there's been no subpoena ducis tecum with the depo notice. Is that just posturing, or is that a legitimate objection that could apply also to the phone?
No, I don't think that's a legit. I mean, I agree with Angela that what you bring into the deposition room is really fair game. Now, I've seen some people say that, if you bring a laptop into the deposition room, they'll put a deposition sticker on an exhibit sticker on the laptop and make an exhibit. Now, I don't know if that's really going to pass muster, because you can't just take somebody's laptop and give it to the court reporter and make copies of it. So I'm not sure you can quite go that far, but as far as requesting to see anything like that, I don't think you need a subpoena. If it's on their person and it's not private, which a driver's license certainly isn't, and a lot of stuff on a cell phone will not be, I don't think that's necessarily a valid objection. That being said, our phones contain so much of our lives these days. I mean, there's very little personal or business stuff that I don't transact in some capacity on my phone, including banking, personal emails, social media, all of that kind of stuff. And a lot of it is going to be irrelevant to whatever litigation you're being deposed in, and a lot of it may be private in nature. So I could see those types of objections being made to just turning over the phone and letting somebody just go through all the contents. And in that sense, maybe somebody could object that there's no subpoena. But if you bring it, in some sense, it's fair game. So it's kind of a toss-up as to how that's going to come down. But I could see courts ultimately going either way, saying either, no, you can't get at somebody's private phone. You have to make a narrowly tailored discovery request. But I can see some courts saying, look, you brought it to the deposition. Your social media is obviously relevant in this case. They can access that through your phone. You haven't produced it in discovery requests. This is the opportunity for the attorney to look at it.
Right. And even if you're not looking at the actual contents themselves, it's very powerful when you've gotten a discovery response back saying, oh, I only have a Facebook account, or I only have Facebook and Instagram, and they're in a depo, and you ask them the question again, what social media sites do you belong to? Do you have an account with? And they tell you, Facebook and Instagram. I said, you have your phone with you? Yes. Can you just verify for me on your phone that you don't have any other social media platform apps on there? If they sit there and fight with you about that, you're not asking them to see the contents. You're not asking them, it's not going to look good, quite frankly, that they won't even look on their phone to tell you which social media apps they have. And then when they do, because, that's, you would hope that they would anyway, and they start telling you that there's 10 different kinds on there, and they've sworn in discovery that they were only members of 2, they lose all credibility with the judge, and you can get so much more now than you could have before. So either way, even if you can't see the actual contents, taking them through, what photo apps do you use? Do you use Dropbox? Are you saving pictures on Dropbox? Are you saving them only on your iPhone? Do you have an Android? What other, app do you have that saves your pictures and videos? What editing software do you have for your pictures and videos that saves the photos and the videos as well? I mean, you could sit there for hours, quite frankly, depending on who it is, but yeah. I'm no fun in a depo if you're on the other.
I think we've all learned that. No, that's great. And I think those are things that, sometimes we get so in our heads that we don't want to offend the other person, or we don't want to invade the other person's privacy, that could be something that could help our case. Now, Angela, moving on to kind of a different question, and one that I'm certain none of our viewers or anyone here would ever have engaged in, but we all know, and we've talked about this, that we cannot mess with evidence, we cannot tamper, anything like that. What about those people who counsel their clients to just clean up their Facebook? And I know Jason mentioned the fact of, just stop posting once you get into litigation. It's not ethical. But what is that line of cleaning up your Facebook? Is that removing, maybe some graphics that are not so pleasant, that have nothing to do with this, the case that's currently at hand, or what's that line there, if there's one?
Again, it's another cautionary tale. Okay, which is and the way that I like to describe this is, if you're not comfortable with something being on the front page of the New York Times or the Wall Street Journal, it's not something that you should post, period. A lot of people get into political debates on there. They put some jokes on there that might be funny, but probably not to everybody. Might be offensive to some people. All kinds of things wind up on people's social media posts, things that are off color, that just color your perception of who this person is, either in the eyes of the judge, in the eyes of the jury, in the eyes of expert witnesses, whatever it happens to be. So I think lawyers have to be extremely careful. I think the appropriate way to handle that, which is the way I handle it, I'm sure the way Jason handles it as well, is listen, if we're going to do, and you don't just file litigation, okay? And typically when you have litigation filed against you, it's coming. It's rarely a surprise. You have to have that talk with your clients as early as humanly possible. Eyes are going to be on you now, either because it's media worthy, which happens sometimes with my clients, or because the other side's going to be looking and you don't know how prolific they're going to be at the search. So just please be mindful. If you have a question as to whether you should post something or not, call me. Ask me the question, please. I prefer you do that versus posting it and then we have to deal with the consequences. I've got to tell you, there's nothing better for me. I'm typically on the defense side. There's nothing better for me than when liability is kind of like, 50-50 and the other side does something incredibly stupid that, gives me all this leverage because of a collateral issue that had nothing to do with the case. But there's nothing worse when you're defense counsel and you have a corporate client or somebody, a high net worth individual, and you had great defenses. And because they did something really stupid by deleting something on social media or posting something somewhere, they've taken away all those great defenses. And now it's all going to be about a collateral issue and your hands are tied. It's just not smart. And the clients have to be made aware of the repercussions because most of them have no clue.
Right. It's nothing better than striking gold, but then you don't want to call the pot calling the kettle black, right? When you're looking at the other side. Jason, let's put on, I know that you do some defense work too, but let's say we're on the plaintiff side here and we have, defense has found some gold. What are some potential exclusions that you can argue, for your client for social media evidence? In the world of cancel culture, we know that there's a lot of people that dig really deep. So what are some things that you would use to kind of help your client out if they decided not to take Angela's advice and just post?
Right.
They never do, by the way. They never take the
Yes, I mean, there are several ways to try and keep out social media evidence. I mean, some stuff is going to be relevant and you just can't get around it, but you can always argue relevance. I mean, if it's something that's tangential to the actual dispute and, again, the example of, the other side's was having an affair or something like that, and it's a breach of contract case or a defamation case that has nothing to do with an affair, then, that's just going to be character evidence and you can get it out on those grounds. You can get it out on Rule 403 grounds, potentially, if it's, the potential for prejudice is greater than it's outweighs the relevancy of the information. But yeah, I mean, relevance is going to be the biggest issue. Privacy is rarely going to help you. If the information was gotten by improper means, that may be a grounds for trying to exclude it. So if you discover that, the opposing attorney pretended to be somebody else and got to the information that way, I would certainly make a big deal out of that and try to get it excluded on that ground. Although that doesn't necessarily impact the relevance of the information, that may persuade the judge that, yeah, this should not have been obtained this way. I'm not going to let it in. It's kind of a bit of a sanction. So those are really kind of the main grounds to try to keep this information out. I mean, you can also, depending on how it was obtained and whether it's even your own information. So it could be from somebody else's social media account. I mean, you could argue that it's not authentic. If it's somebody else's statement on your social media account, so it's not a statement from you that would be deemed an admission, you could argue that it's hearsay. If you get somebody else showing up in your social media account, making statements that are, contrary to your interest, but, you don't, why they said that, and you don't, agree with what they said necessarily, you could argue that their statements are hearsay and inadmissible, and potentially inauthentic, since you don't know who's actually posting. And then as far as resisting discovery itself on social media, relevance is generally going to be your biggest argument. That, look, they're asking for all of my social media accounts dating back for 10 years. This dispute came up 2 years ago. It doesn't involve all the issues that are on my social media. I'm willing to produce a narrow scope, but not everything they're asking for. So it can be a give and take. Often, if you just oppose producing anything, then you might have to produce everything. Whereas if you agree to give a narrow amount of information, then you may be able to preserve a lot of what you don't want to produce.
Right. It's interesting to see social media kind of fit these boxes that have been around, the law for so long, whether that's medical records dating back 10 years, and we're only talking about, an accident that happened this year. But there's so many different challenges to social media that, aren't presented in those boxes that we've already had. And, moving on from pre-lit to kind of the meat of litigation to jury. Angela, I want to start with you on, jury selection in social media has been a big thing. It's kind of, jury selection before jury selection even starts with the social media. So are social media searches on investigating, potential jurors and seated jurors, witnesses, even consultants, is that allowed? And how can you ethically do it? And can you use information that you find to strike jurors or impeach witnesses or things like that?
So it's funny because this actually brings up a gray area that hasn't really been fleshed out so much, as far as legal opinions go. And I think one of the reasons it hasn't really been dealt with as much as it should, quite frankly, is because 99% of cases settle, whether you're talking criminal, civil, and then, given everything that's happened in the last year and a half. I actually got to do a federal jury trial in a courtroom for like that 1 week, 2 months ago, where we thought it was going to be fine before the, variant. By the time the week was over, the judges panicked that, he had to put masks on all of us and kick us out to some Zoom room somewhere. But the gray area is this, and you want to be very careful. I use social media all the time and look at their experts, their lawyers. Sometimes the lawyer on the other side has taken the case because of a relationship, either with a family member of the plaintiff, or they're related, or they're friends. There's some, you can just tell that there's a prior relationship there, and I'm curious to know what that dynamic is. So I may take a look. I use it for their witnesses. I use it for their family members. We do background searches. We find out who their family members are, because sometimes, even though the plaintiff themselves may have their privacy settings, at the highest level, their kids don't, or their grandma doesn't. You can get in that way. But here's the gray area. Let's say that you are in the process of jury selection or in the middle of trial, and one of the jurors has a profile on LinkedIn or posts a story on Instagram. What happens if that juror has a premium account on LinkedIn, or is checking out who can see their story on Instagram, which isn't the case for regular posts?
Right.
So now the juror knows that they're being stalked by you. Does that cross the line? In my opinion, yes, it does. And you have to be very, very careful. I would not play those games with jurors, with judges, with anyone having anything to do with the judicial staff. And quite frankly, even with some expert witnesses, I would be very careful with that, because it's not really necessarily addressed specifically in the ethics rules that I'm aware of, that one kind of narrow issue. And I've never really seen any case law specifically dealing with that issue, but I could see where it could become a huge issue. And listen, you don't want to litigate for 3 years, 4 years, find yourself in the middle of a jury trial, and have an issue like that come up, because not only are you going to lose that client, that client's going to tell other clients. So you want to be very careful where they can see that you're looking without having liked.
Yeah, my heart skips a beat every time I click on a LinkedIn because I'm like, are they going to see me? Are they going to see me looking?
And by the way, to that end, if you do have the premium feature on LinkedIn, which I personally highly recommend, because I think LinkedIn is such an underused business development, and information tool, you can actually set your privacy settings on LinkedIn so that when you are looking at other people's profiles, you're completely anonymous. Some people set it so you can see partner at law firm, whatever it is, you can actually set it so that they don't see you at all looking at their page. And if you're going to be stalking people on LinkedIn, regardless of whether it's, for good or bad, I highly suggest you make yourself, incognito.
No, absolutely. And I mean, that brings up a good point. I mean, there are some courts out there that think, Jason, to zealously advocate for your client, you have to go through these measures and you have to look at, the witnesses' Facebook and the consultants and, the potential jurors. What is the feel here in Texas on doing those things? And do you have anything else to add to Angela's statement about, creeping on jurors, for lack of a better term?
Right now, I think it really depends on the case and the context as to whether that's something that's going to be expected of an attorney, to really go and look on the social media. I mean, obviously, as a zealous advocate, you're expected to use publicly available sources to find information that's going to be helpful to your case and your client. And I think it is perfectly okay to, especially during jury selection, to investigate jurors through public sources. And Facebook is obviously a good one, because if they've got a public Facebook profile, they're not going to know that you're looking at them, but you can see if they've posted something that would indicate some kind of bias for or against your client that you want to bring to the court's attention, or that you just want to use a peremptory strike to get them out of the jury pool. That's perfectly fine. I do agree with Angela that you run a major risk if they are able to detect that you've been stalking them, because they may end up on that jury, and that may prejudice them against you. I'd be less inclined to look into what jurors are doing during a trial. I mean, obviously, it's more for the interest of the proceeding and whatnot than assessing bias to see if a juror is out there making posts during trial. I mean, they're not supposed to be, and you don't want them to be, but as long as it doesn't have anything to do with the case and it doesn't indicate that they're biased for or against your client, it probably doesn't matter. But again, I would highly recommend either you or your jury consultant or your paralegal do as much research on the jury pool as you can, through public sources where you're not going to be identified prior to jury selection. What you do after that does come with some risks, and obviously, being caught in the process could backfire against you.
Right.
But I'm not aware of any Texas case that has imposed any kind of particular duty to, use any level of investigation, especially as to social media, as to jurors or witnesses or anybody else.
Right.
Sometimes you just don't have time. Sometimes the judge, brings in, 40, 30, whatever the case may be, sits them down, depending on whether it's federal, state court. Some federal judges don't even let you ask a question. He asks the questions, you got your strikes, he sits the jury, you're done in an hour and you got what you got, kind of deal. So sometimes there's not even enough time.
Right. And on the other side,
I think the first thing I do, and I'm sure the first thing Angela does, and most lawyers probably do, especially younger lawyers, when you hear of a new attorney coming into a case or a new witness or something like that, the first thing you're going to do is Google this person and see what comes up and find out, okay, what's the background of this person? What are their connections to other attorneys and parties? What have they done? What have they said online? So, I mean, that's absolutely advisable to do, and to get that information early.
Right. Jason, sticking with you on this one, on the other side of this social media is what you kind of alluded to, and that was the jurors' use of social media, during the case. Most judges include a comment about social media, when cautioning jurors not to discuss with any of the progress with the case or anything like that. But unfortunately, some jurors, sometimes disobey this guideline. What issues do you believe this presents for jurors regarding outside sources, use of social media? I know that we have a Texas Rules of Civil Procedure that caution the jury on this usage.
Yeah, I mean, the issue is obviously, and it's not just social media. It can be, using your phone during a trial as a juror to just access the internet or access media or Google, a party, just like we have the urge and as we should to Google anything we can find out about witnesses and jurors. They may have that same urge to do that about the underlying facts, about the party, to try to get, even though they're instructed not to. And unfortunately, there's, courts can instruct jurors not to use their phones and maybe even have them turn in their phones, when they enter the courthouse and only pick them up when they leave. Although I'm not aware of a lot of courts that do that, since people need their phones for a lot of things, including communication being most important. But there's very little you can do, and it's rare that people are going to be sequestered from accessing the internet at all during a trial, and that comes with risks. So even if somebody's not intending to find out something about the case, if it's a high profile case, just pulling up Google may generate a news alert about the case that jurors shouldn't be seeing. So it's really tough. It's a really tall order for a judge to tell a juror they can't access their phone or can't access the internet, or that they even can't access social media during a trial. Now, some judges will do it, and shorter trials are easier. But if you got jurors sitting for 2 weeks and they're not allowed any access to the outside world, especially in a civil case. I mean, criminal cases, it's easier to impose that type of sequestration. But in a civil case, it's harder for judges to do that. So, I mean, what you got to do is have judges give very clear and very specific instructions that are designed to truly limit the jurors from accessing information that they shouldn't, or that could influence the case. And, to the extent you can do it without getting caught by the jurors as spying on them, if you suspect the juror is doing something that they shouldn't be doing, or getting outside influences, to monitor their accounts. And if you see that they've been posting something about what happened to the trial, or this witness was totally lying, see this article, then obviously that could be a good way to disqualify that juror and possibly lead to a mistrial. So that's why you monitor it. That rarely happens. I rarely hear of social media causing a mistrial, but it is possible.
Right. I mean, and with your own clients, if I'm strict about it during the litigation, during trial, I'm like, there will be no posting of any kind by you or your family or anyone else or any witness or anybody or any lawyer or anything, because you never know who's looking, and there's no way once that juror leaves to go home to control them. And even if they're not looking on their own phone, by the way, they're not really supposed to talk about the case. Obviously, they're going to tell their wife or their husband or their boyfriend or their girlfriend or their kids what they're doing. Okay. Like, come on, or enough information so they know what case it is. And if it turns out to be a case that's been in the news, how are you going to stop those kids? How are you going to stop the significant other? How are you going to stop the friends from, potentially sharing or doing their own investigation? So again, if you're in trial or you have a big hearing coming up, it's imperative that you have that conversation with your client and anyone else at the company or anyone else in your client's family about, please, status quo. Okay. Let's not make everything harder than it has to be. No posting of any kind until we pass, X, or whatever the case may be, because it muddies the water.
It always amazes me how difficult it is for people to just not post.
Exactly.
It seems like it's pulling teeth. Angela, we have a few minutes left here. So if anybody has any questions, please do the Q&A function. But on a more, on the other side of the social media spectrum is, judges. They're on social media. They have friends on Facebook. And many judges on Facebook are friendly with attorneys, some of whom may be practicing in their court. For example, if you lose a case and opposing counsel is friendly with the judge, celebrated his birthday together, does that interaction affect the outcome? And if so, is there grounds for appeal?
I think early on, that was when I think many people, especially many people sitting on benches at appellate and higher courts, didn't really understand social media. I think that was the sense that it's not a good idea. And you also just want to be careful. Again, you're a public figure, you're a politician, you're a judge, whether you're appointed or elected. So I have a lot of friends who are judges that I have pictures having drinks with, and I, have appeals pending before them or cases pending before them. And going back to something Jason said earlier, I disclose that to the opposing side. To the extent that they happen to be a good friend of mine, or I'm going to walk into the courtroom and we're on a, first name basis, although I never do that, even if it's one of my best friends in a courtroom, and it's still judge in your honor. But you just want to be open and honest about it. And some judges take the position, I'm not going to be on it at all. Other judges most judges, I think nowadays, at least in Florida, take the position, I'm going to friend whoever I want and just be careful about what I post. But again, I don't think it's an ethics violation for a judge to be connected to, especially on a platform like LinkedIn, for example, a lawyer in their community. They need to get elected. They need to have fundraisers. Okay. They need to have their circle of people too. So I think that has changed. The perception on that has changed a lot over the course of the last couple of years. Yeah. And again, it's about being forthright and honest with the other side.
Right.
I think being friends is fine between litigators and judges, but what judges and litigators have a duty to do is to avoid the appearance of impropriety and avoid the appearance of any type of bias. Even if there is no actual bias, you've got to avoid the public appearance of that. And social media is public; everybody can see it. So while being friends is fine, having communications that could be considered ex parte, that's obviously problematic. And that's part of what social media is a communication platform. So, even public communications or, just not purely private communications can be problematic if it's between a litigator and a judge who's litigating or where the litigator's litigating that court. Obviously, if it has nothing to do with the case, maybe it's okay, but that can still raise concerns. And judges need to be, careful, obviously, about what they post. You don't want to do anything that's going to imply bias. And judges, like everyone else, need to be aware that their social media accounts can go back for years. And if at some point you posted something that could indicate you've got bias against a particular company or a particular party for reasons that have nothing to do with the case at hand, that could be, create a bad appearance, or it could even be a ground for recusal. So as Angela said, I think it's very important for both judges and lawyers to be forthcoming about, their friendships, social media relationships and whatnot, so that nobody feels like they're being left in the dark about that. And rational decisions can be made on the front end.
Yeah, no, absolutely. Jason, time for one more question for you. I'd be remiss if we didn't talk about this one. So in 2020, the Texas Rules of Civil Procedure 106 and 108A now allow a party to make a motion to the court to allow for service in any other manner, including electronically by social media, email, or other technology that the statement or other evidence shows will be reasonably effective to give the defendant notice of the suit, end quote. How can you do this? And what is the burden to prove to show that the service by social media is the best alternative method and that that's the person that you intend to receive the notice?
Right. So I think it's the same burden that you would face when you're trying any alternative method of service, which alternative methods of service have been around forever. I mean, the amendment to the rule specifically referenced social media, I guess adds that as an option, but I think previously it was probably an option under just the broader rules anyway. But the burden you have to meet is basically to show that you've diligently exhausted all methods of traditional service to no avail. And then you need to show that social media is a reasonably effective way of serving the person. So that they're likely to get notice of the suit if served through social media. Now, how do you actually do it? I mean, I guess you could make a Facebook post that includes a picture of the citation and
the related messenger apps.
Right.
Yeah.
Or you could do it through the app. Yeah. And you could certainly do that through LinkedIn. I mean, obviously you'd have to establish some kind of friendship with the person, I think, before you're able to effectively do that. But I mean, I think that's the way you would do it. Now, I'm not sure that that's any better than just doing traditional service by publication, which has been around for a long time. And, you can publish something in a newspaper and, obviously it's less likely that somebody's going to learn about the lawsuit that way. But most courts, if you're seeking a default judgment, will consider that effective service if everything else has been exhausted. But if you really want the person to show up and appear in the lawsuit and you've exhausted everything, social media can be an option. I've never done it. I've served people by email in federal court before. Somebody who was being very, very sneaky about who they were and where they were, but kept on using the same email address. That's been deemed an effective method of service. And I'm sure social media can be too under a similar type of showing.
Yeah.
They've been considering it in a variety of jurisdictions. The reason why is because more and more what we're seeing is these companies that are just shells that have a registered agent that's another shell, that's like a mailbox, et cetera, PO box that nobody ever goes to anymore, because now they'll just scan and send you your mail. So locating an actual real person is becoming more and more difficult, but yet they're actively posting. Typically companies are actively posting on social media. So clearly somebody on behalf of the company is acting there where they may just ignore the email. So I know that's one of the reasons they included it. It's just kind of the world we live in, unfortunately.
Yeah, it's a crazy world that we live in with this social media. As you mentioned, most of the viewers here today on the CLE will be the people that know, how to screenshot a Facebook post or what it means to share on Facebook and Instagram and Snapchat is a big one that we haven't talked about today. But that's a whole nother talk about being able to see who watched your stuff and who didn't watch your stuff. It's a crazy world. But I think that's all the time we have for today. I don't see any questions or of the chat, but if you have any parting words that you would like to give some young attorneys who social media will inevitably be their life for the next, until their career is over, and you better make sure not to say anything bad about Amazon, because you may be a judge that has Amazon in front of your court one day.
And
so I'll leave it open to y'all for any closing remarks.
You never know. So if you're even remotely hesitant or you have a question about it, don't post it. I mean, that's my advice.
Yeah, I think my parting words would be, counsel your clients early on social media use, especially if you've got a client that you work with a lot, pre-litigation, before disputes even arise, counsel them on what they should and shouldn't do on social media. And then as a young attorney, I think it's really valuable to be a technology expert because that will make you a go-to person. So understanding social media, especially, the new and emerging platforms that Angela and I may not even know about yet. There are a lot of things out there, and the more you can be the technology expert and the go-to person on, I know how to do this, I know how to get this information, I know how this platform works, that really adds value to you on a litigation team.
Yeah, and one really quick last thing, especially if you're going to be at a big firm, be very careful with the politics and the sensitive subject matter on social media. You're not an individual anymore. You're an attorney at a large firm. You're an employee potentially at a large corporation. You don't want to be that first or second year associate that a client disagrees with a post and ends up firing a firm over. And it turns out to be a huge client of the firm, because there goes your career, there goes your job. Be mindful of it. I know it's not fair. But it's just the reality of the world we live in. And if you want a career, especially at a mid-sized or large firm, if you're going to have your own firm, you can do whatever you want. Other than that, you got to be a good corporate citizen. You just have to be, until you have the power to do whatever you want when you've been practicing for, way longer than Jason and I.
No, and I think those are great parting words. I had a partner say, you always find cases that have really good social media gold. And I said, or do I know how to find the gold that's there? And there always is one if you keep looking. But again, thank you both so much. Jason, Angela, thank you for taking time out of your day to educate, the young lawyers here on social media. As Jason said, there's so many platforms out there. We may not know. Next year, we'll be talking about Parler or the whatever other app that has come out since then. And parlaying into Angela, we will be having a second part of our social media September 21st at 12 o'clock. We'll be having cancel culture at work, social media issues affecting employers and employees. So what a great segue, Angela.
I didn't even know that. That was
Yeah. So please join us for that. It'll be Zoom as well. And on behalf of GAYL, and we appreciate you being here. Thank you all so much, and have a great rest of your day.
All right, thank
Thanks,
you.
everybody. Have a great week.